today we're going to wrap up this module, or no, we'll wrap up my recording day anyway, with some legal regulations from the American perspective. There have been a lot of public concerns about testing. And some of these started in 1969 when there was this pretty big controversial publication by Arthur Jensen in the Harvard Educational Review about how much, in this paper, talked about how much can we boost IQ and scholastic achievement. Now, Jensen has kind of framed this finding not so great. So here's what Jensen says. So genetic factors are strongly implicated in the average Negro white intelligence difference. End quote. Just to be clear, that's Arthur Jensen in 1969. It's not me. So after that academic article, there was a huge, I don't know how to overstate this, huge outpouring of public and professional attention to the nature-nurture debate of cognitive ability and racial differences. As a behavior geneticist, I'm very aware of, like, there's a huge controversy that I'm not going to even touch with a 10-foot pole. There are racial differences in test performance. The reasons for those are obviously super nuanced, and I'm trying to figure out how to phrase this in a way that is not awful. I'm going to keep this all in so you can, like, see that I'm grappling. So, you know what? I'm not gonna get into the nuances of this. We're not in a behavior genetics class. I'm happy to, like, book some office hours with me so I can talk about some of the nuance and, like, how this kind of stuff gets really misinterpreted really fast. But just to be clear, I don't endorse this idea that there are genetic causes. Like, it's not like one group of people is genetically superior or inferior at all. As I've kind of hinted in a couple other videos, like, my family on my mother's side, my Eastern European grandma, escaped Germany, while many of my cousins did not. So, like, I'm very mindful of this genetic interpretation, and there's a lot of nuance that is just beyond the scope of this class. Anyway, let's keep going. So, in 1972, kind of in response to this uproar, U.S. Select Committee on Equal Education Opportunities was preparing hearings on the matter. They were ended up canceled soon after, according to this Haney writing in 1981, because they promised to be too controversial. So the extent of public concern for psychological assessments is reflected with the extensive involvement of the government in many aspects of testing process, especially in recent decades. Assessment has been affected in numerous and important ways by legislation activities, the executive branch and judicial branch, state governments. I'm going to give you some samplings and just a little comment on the difference between legislation and litigation. So legislation is what's written by lawmakers. It's the American with Disabilities Act. It's, like, written into law and followed that way. While litigation is kind of written as a result of specific lawsuits where judges kind of interpret the law The Americans with Disabilities Act is my favorite because it affects me, so I'm super biased. But the Americans with Disabilities Act of 1990 essentially set out that employment testing materials and procedures must be essential to the job at hand and not discriminate against persons with handicaps. So the amended Civil Rights Act of 1964, also known as the Equal Opportunity Employment Act, said that it is unlawful, it's an unlawful employment practice to adjust the score of use different cutoff scores for, or otherwise alter the results of employment-related tests on the basis of race, religion, sex, or national origin. So, yeah, so you can't control for stuff. This is unfortunate. In some ways. It's a poor choice of words. But okay, let's talk about FERPA! So, the Family Education Rights and Privacy Act 1974 mandated that parents and eligible students be given access to school records. So this granted the right to challenging findings in records by a hearing as well. All right, so that's why your parents can't email me and ask about how you're doing in class, because it's a violation of federal law for me to tell them anything unless you authorize. So please don't authorize. Yeah, so HIPAA is next. So HIPAA is the Health Insurance Portability and Accountability Act of 1996. It provides federal privacy standards that limit the way that healthcare providers and others can use patients' personal information, including tests. So so once you turn 18, your healthcare provider cannot share anything with your parents. And if they do, they're in violation of the law, assuming you're in the United States. Next, we've got tons of different variations of this, but the Education for All Handicapped Children. This has been amended several times, started in 1975, and thereafter it includes the IDEA of 97 and 2004. But what it does is it mandates screenings for children with suspected mental or physical handicaps. So once identified, individual children must be evaluated by a professional team qualified to determine a child's special educational needs. So the child must be reevaluated periodically. This was amended in 1986 to extend disability-related protections down to infants and toddlers. So IDEA is Individuals with Disabilities in Education Act. And so this one deterred inappropriate placement into special education programs due to cultural differences. So it encouraged accommodation of existing testing instruments and other alternative means for the purpose of gauging the progress of special education students as measured by state and district-wide assessments. Now, the Americans with Disabilities Act is like the grown-up version, and it's my favorite for entirely selfish reasons. So anyway, last one, No Child Left Behind, NCLB of 2001. So this is a reauthorized version of the Elementary and Secondary Education Act. It was designed to close the achievement gap between minority and non-minority students and between disadvantaged children and their more advantaged peers by, among other things, setting strict standards for school accountability, establishing periodic assessments to gauge the progress of school districts in improving test scores. It had some problems because it didn't really take into account regression towards the mean. So if you have above average class, on average they'll go closer to the mean, and a below average will go up. And so if you identify those in the worst bottom third, on average they're expected to go up by chance alone, while the top third are expected to go down by chance alone. So there's some problems. Okay, so some significant litigation. This is just all U.S. cases, just some that are more recent than the textbook for the most part. Okay, so Hobson versus Hansen, 1967. The court ruled that ability tests developed on whites could not lawfully used to track black students in the school system, and that to do so would result in resegregation of desegregated schools. So essentially what this one means is that you had to have norm reference groups that were not just white kids from the Princeton, New Jersey area, or you had to actually have tests that were representative of your subjects and not just convenience samples. Education testing services is out in Princeton, New Jersey, for the most part. So that's where they got their subjects. Okay, next we got Tarasoff versus Regents of the University of California. I talked about this one. Therapists and presumably psychological assessors must reveal privileged information if a third party is endangered. So in the words of the court, protection privileges end when the public peril begins. Next, we got Larry P. versus Riles. So this was litigated, or at least wrapped up in 1979 and reaffirmed by the same judge in 1986. So this California judge ruled that the use of intelligence tests to place African American children in special classes had a discriminatory impact because the tests were racially and culturally biased. So this is clearly an issue. So Deborah P. versus Burlington, 1981. So the federal court ruled that minimum competency testing in Florida was unconstitutional because it perpetuated the effects of past discrimination. All right. Got Griggs versus Duke Power Company, 1971. Black employees brought suit against a private company for discriminatory hiring practices, and the Supreme Court found problems with the broad and general testing devices and ruled that tests must fairly measure the knowledge or skills acquired by a particular job. Next, we got Albemarle, which is probably not how you pronounce it, Paper Company versus Moody, 1976. An industrial psychologist at a paper mill found that scores on a general ability test predicted measures of job performance. However, as a group, whites scored better than blacks on the test. And in this case, the U.S. District Court found the use of the test to be sufficiently job-related. However, an appeals court did not. So it ruled that discrimination had occurred, however unintended. So Regents of the University of California versus Bach, 1978. So when Alan Bach, whose last name I'm probably mispronouncing, learned that his test scores were higher than some minority students who had gained admission to the University of California Davis Medical School, he sued. A highly divided Supreme Court agreed that Bach should be admitted, but did not preclude the use of diversity considerations in admission decisions. So in Allen versus District of Columbia, 1993, blacks scored lower than whites on a city fire department promotion test based on specific aspects of firefighting. The court found in favor of the fire department, ruling that the promotion examination was a valid measure of abilities and probable future success of the individuals taking the test. It's a contentious area where there are group level differences. Okay, so Arand Constructors Incorporated versus Pina et al. 1995. So a construction firm competed for a federal contract, brought suit against the federal government after losing a bid to a minority-controlled competitor, which the government retained instead of the interest of in the interest of affirmative action. The Supreme Court, in a close ruling 5-4, found in favor of the plaintiff, ruling that the government's affirmative action policy violated the Equal Protections Clause of the 14th Amendment. The court ruled that the government may treat people differently because of their race only for the most compelling reasons. End quote. Jaffe versus Redmond. Communication between a psychotherapist and patient, and presumably a psychological assessor and client is privileged in federal courts. Which is nice. All right. So Grutter versus Bollinger, 2003. In a highly divided decision, Supreme Court cases like this are always like super divisive. The Supreme Court approved the use of race in admissions decisions on a time-limited basis to further the education benefits that flow from a diverse student body. There are some more recent ones that are pretty contentious, but I think we got enough here. So that is it for legal regulations. I've focused on the United States because that is what I'm familiar with. And yeah, I'll see y'all later. Bye.